Hey, I'm Beau. I'm an attorney. I've been practicing in personal injury for the last 10 years, both on the plaintiff side and the defense side. What I'm hoping to do is provide a unique perspective to personal injury law and provide some education materials both to consumers and potential clients so that they can make better decisions. All right, so first thing, why the heck should you listen to me? I'm an attorney. I've been in practice in primarily personal injury for the last 10 years. That's the easy part. But to tell you who I am, I'm originally from a small rural area, much like this, and I was an absolute jock in high school, didn't pay much attention in school, played football, and I had a number of jobs. You name a crap job, I probably had it. From loading furniture to pulling red rice, climbing up on roofs, carrying shingles up, you name it, I probably did it. But for football, I wouldn't even have gone to college, most likely. When I got to college, again, just complete jock, and I found myself in a rather precarious situation. I was placed on academic probation, and I was getting ready to get kicked out of school. At the time, I was not too happy about it, but looking back, it's one of the best things that ever happened to me. And the reason is because it placed me in a position where I had to make a decision. I had to start playing the long game. I could either apply myself in school and hopefully get a good job, or I could get kicked out of school and go back to washing cars or climbing up on roofs or whatever I was doing at the time. Luckily, I chose to bear down, did really well my last couple of years in college, and I was able to get into law school on my first try. That didn't last very long for me. My first stint in law school was about a month. I decided to join the Army just because at that point in time I wasn't ready to resign myself to a desk. I spent 5 years in the Army in the infantry, served in Iraq, and when I got back, at this point in time, I had a family. So I decided to go back to law school then to try to support my family. One interesting fact is that up until the day that I enrolled in law school, I didn't know a lawyer. I'd never had a conversation with an attorney. I just knew that through my undergrad classes that was an area of education that I was interested in. And I say that to say this, it's a good segue into our topic. How is a person who clearly has a need for a lawyer supposed to decide which lawyer they're going to engage if they don't know any attorneys, if they're not a lawyer, if they don't have connections to that world? Those people are left to make their decision based on the information that's available. Unfortunately, most of the information that's available is just straight marketing material. You watch TV and you see the commercials; those are lawyer commercials. They're not informative. They're not helping the consumer in any sort of way. They're just jumping up and down saying, "Hey, hire me. This is what I can do for you." But they're doing it through a dollar amount. They're not explaining the process, explaining the differences in cases, or explaining the strategies that they can use to actually get a good recovery for their client. You go online and you look at Google reviews. Well, Google reviews, as you all know, come in one of two flavors: 1 star and 5 star for the most part. 1 star indicates that somebody was not happy. 5 star means someone was probably trying to be nice. And again, these are little clips. They're, a few sentences about this law firm that, again, don't provide any information to the client, the potential client, as to how they should go about making their decision. You look at the lawyer's website. Again, more than likely than not, this is going to be just straight marketing material. There may be some legal content on there. We have some good content on our site, and the purpose of it is to try to educate people to the issues and things they need to be thinking about as they move forward. But the normal consumer is just fed a ton of marketing, and it doesn't help anyone. My practice in the last 10 years has been on both sides of the V, is what we call it. And what that means is I've represented people who were injured due to no fault of their own, whether it be a slip fall, a car wreck, a truck wreck, a construction accident, a shooting due to negligent security, medical malpractice, nursing home abuse, or in some cases, where staff members at a nursing home have actually beat on patients. We've represented those people and their families. And at the same time, we've represented insurance companies, the persons who defend those cases. More often than not in this area, it's us, it's me. We represent both the corporate entities, the individual nurses, doctors, so on and so forth, and in some cases, the insurance companies. And we've done this for over a decade at this point. And I feel that it gives us a very unique perspective concerning the issues that a person's going to face when they bring one of these types of cases. And my hope is to shed some light through these, I guess they're podcast videos, upon those issues so that people can get some information to try to make a decision off of that's not just straight marketing material, because that's the purpose of this. It's not to market to you. It's to educate you. So hopefully it'll be well received. So where does the problem start? My personal opinion, the problem started when attorneys were allowed to advertise. Prior to 1977, lawyers were not allowed to just openly advertise their services. 1977, there was a U.S. Supreme Court case that said that this advertisement is commercial speech, therefore it's protected under the First Amendment. Flash forward, you've got lawyers dancing on top of 18-wheelers throwing $100 bills. I'm not sure how that's really protected speech, but I'm not on the Supreme Court either. This marketing phenomenon has set up an absolute race to the bottom. Initially, you would have lawyers that would just put up, classy billboards, classy advertisements. But let's be honest, trash sells. The more $100 bills you can throw out, the more noise you can make, the more people that come and sign up with you. I've seen this in practices. These mass plaintiffs' PI firms that employ dozens, if not hundreds, of lawyers, more often than not, have suspect advertising. They use slogans like, size matters, saying, hey, we've got a lot more attorneys, it matters. Or, just call us once. Or we've got strong arms. Or 1-800, whatever it may be. Or they'll have a catchy jingle of some sort. That's the hook. That's the hook they're using to pull in these consumers who have absolutely no idea what they're doing. It's as if, they've blindfolded a sheep and they're leading them down the way saying, hey, don't worry, I'm going to help you, all the while not explaining to them how they're going to help them or what they're going to go through. And it can become predatory. There is a firm right now, I use the term firm loosely because I'm not really sure what they are. And I'm going to use their name because I don't think they're a law firm, so I can say their name, Mighty Law. Mighty Law's entire marketing platform is that billboard lawyers are taking advantage of you. Trust us instead. And they have a lower fee, and they have a unique marketing aspect. They give you, some sort of client's bill of rights, so on and so forth. And they're really pushing this lower fee, trying to attack these mass plaintiff's personal injury firms. And they're calling these personal injury firms predatory. At the same time, Mighty Law is doing the exact same thing, just under a different marketing scheme. It's all marketing. I would encourage you or anyone listening to put the marketing aside, not pay attention to it. I mean, sure, you see marketing, you get a list of names and a list of firms to consider, but that you do some sort of independent research on those firms, that you actually sit down and interview some of those lawyers, make them interview for you, that you talk to them about their fee structures and what they're going to do and how they're going to go about improving your case, not just settling your case, but improving your case. And if the law firm's not willing to do that, or they're not willing to sit down and listen to you and address all your concerns, then maybe you should look somewhere else. Attorneys are businessmen. Just like any other business, The object, one of the objects at least, is to make money. So you have these large marketing firms that are spending hundreds of thousands, if not millions of dollars in local markets. That's not statewide. I'm talking about in South Georgia. They're spending millions of dollars. The purpose of that is to get as many cases as they can into the door. And then the purpose is to process those cases as cheaply as possible with the minimum number of lawyers that they need, and then produce a result that the client will accept, not necessarily will live with. You have attorneys at these mass firms with hundreds of cases assigned to them personally, whether it be 100 or 200. 200 is not unheard of to be assigned to one attorney. There is no possible way that an attorney can do justice to 100 cases. Absolutely not. In fact, the American Bar Association has a recommended number of cases of about 50 per attorney. The reason they have that is because people know you cannot give your best effort to 100 people at the same time or 200 people at the same time. There are only so many hours a day. There are so many conscious hours of a week that you can actually work. If you want to know what that's like, come catch me on a Friday. This is a Monday morning. By Friday afternoon, I'm usually mumbling. It just is what it is. I had a client this last Friday that I literally had to stop and apologize to her and tell her, hey, my son's been wrestling this week. I've not gotten to bed till 12:30 for the last 3 nights. I usually get 8 hours of sleep. Now I'm working on 4. I didn't want her to think I was hungover. There's only so many hours in a week that you can actually work. And these firms, these large firms, it's just a money-making thing. They're pushing through as many as they can in any one given time. So don't give in to the marketing. Don't be persuaded by that. Actually get some information before you move forward. Now we've decided that you're going to seek out some information prior to hiring a lawyer. You're not just going to hire somebody based on their marketing. So what are you looking for? Well, first off, I suggest that you hire an attorney who's proven to be competent in the area of law that you're going to be engaged in. Now, what the heck does that mean? You want someone who's handled a case like yours before, but you don't want someone who handles a couple hundred cases like yours at any given time. You want to ask them point blank, how many open cases like mine do you have right now? How many attorneys do you have right now? Do you have a maximum caseload per attorney per paralegal? If they can't answer those questions, you need to think about running. An attorney needs to know, a law firm needs to know how many open cases they have at any one given time. It's just a matter of responsibility. If the lawyer tells you that they have more than 50 or 60 per attorney cases like yours at any given time, the next question you need to ask is, how do you intend to give my case the attention that it deserves? And listen to the attorney's answer. If it makes sense, great. If it doesn't, you may need to think about running. The next thing you need to think about is, what is your track record with cases like mine? Do most of your cases settle, or are they tried? Now, that's a double-edged sword, whether it's settled or tried. I'll tell you, based on, in the last 10 years, I couldn't tell you. It could be 2,000, could be 5,000. I don't know how many thousands of cases that we've seen all the way through. Very few of those go to trial. And I'm not ashamed of that. The reason they don't go to trial is because we're prepared on the front end. Most trials happen when there is a failure of communication between the two parties. When the plaintiff has not done their job, they have not put together their evidence properly, they have not properly documented all the injuries, they've not properly documented how the incident happened, or they've not clearly communicated their position to the opposing side. Or it could just be that someone's being completely unrealistic. That happens, and we'll talk about realistic expectations and what that means. From the defense side, reasons things go to trial. Again, it's failure of communication. It is a failure of the defense lawyer to properly identify what's going on in the case and to get their evidence together and then communicate that to the powers that have the checkbook. Or it may just be unrealistic expectations from the defense side. All we can do is make sure that everybody's drinking out of the same well. If everybody has the same information, assuming you have reasonable people, you should be able to come to some sort of agreement. But at the end of the day, it's not the lawyer's decision whether or not to go to trial. If the client says, I will not accept that, or if the insurer on the other side says, I will not pay that under no circumstances, then you have no choice but to go to trial and put the value or outcome of your case into the hands of a jury. It doesn't happen very often. You have lawyers who like to market the big bad insurance company, the big bad insurance company. Insurance companies are businesses. They have no emotional connection to this whatsoever. It's dollars and cents to them, and at the root, what they're doing is assessing risk. They say, based on these facts, based on this law, we assess our risk level to be X. Given this risk level, we're willing to pay Y to mitigate that risk. It's as simple as that. The plaintiff's attorney, their job is to increase the risk. The defense attorney's job is to identify the risk, first off, and then mitigate that risk. That's the whole chess match going back and forth. Increasing risk, identifying, and mitigating risk. And that's why you see a lot of defense attorneys who do very well as plaintiff's attorneys, because they're trained and have experience identifying that risk. They know how to mitigate it. Therefore, they know how to prevent that mitigation or at least deflate the mitigation of the risk. So identifying the risk, gauging the risk, that's what insurance companies are doing. They're not taking flatly unreasonable positions because they just don't like you or because they just don't like your case. They're taking positions which you believe to be unreasonable because your attorney has not properly identified and increased the risk level. That's what's going on. Now, on the plaintiff side, a little different. Plaintiffs live it. It's personal to them, and I completely understand that. And that needs to be communicated to the insurance company and the defense lawyer. It needs to be communicated not only that it's personal, but how it has impacted your life personally. What you do by doing that is you take away this, hey, this is personal to me, I'm owed more. And by clearly communicating how it has impacted your life, you take it out of that subjective minutia, I hate to say, is what the insurance company is going to look at it as. Oh, they just want more money. And you use it as a way to increase the risk, thereby increasing the value of your case. So it's all in, like my wife says all the time, Beau, it's not what you say, it's how you package it. So it's packaging. It's how you communicate it. More often than not, 99.9% of the time, case is not going to go to trial. It doesn't need to go to trial. The only times I think that a trial is warranted from the plaintiff side is if you've got what I call a free swing. If for whatever reason there's plenty of coverage, there's unlimited coverage, whatever it may be, and there's no top end to gauge it against. So let me back up and explain this. All this negotiation, all this risk assessment has to go on against the backdrop of the limits of coverage. So say there's $100,000 worth of coverage or $1 million worth of coverage, whatever it may be. and also assume that the defendant has no personal assets. Let's put those to the side because that rarely happens. You have to understand that on your best day as a plaintiff, the most you're going to get is X. You know that number, okay? In a situation to where that number doesn't matter, meaning that your case is worth, meaning that there's so much coverage that it's unlikely that your case will eclipse that. So let's say you have a case that's worth $100,000 reasonably, but you know that there's $1 million of coverage on the other side. Well, in that scenario, it may be worth it to the plaintiff to roll the dice and see what a jury comes back with. If you assess the case as, hey, I think on our worst day, the jury may give us $60,000, but on the best day, they may give us $500,000. Looking at those numbers, it might make sense for the plaintiff to actually go forward with the trial. And similar to the plaintiff, the defense knows this. The defense should be having that exact same conversation. Hey, you might want to pay more in this scenario because it's a no-lose. It's a free swing or free roll for the plaintiff. What they stand to lose is a lot less than what they stand to gain. So outside of those scenarios, trials are because people don't do their job. So the next thing I want to talk about is what's commonly referred to as a plaintiff's mill. And what a plaintiff's mill is nothing more than a business model. And it's a business model that generally should be avoided. So how do you identify what is a plaintiff's mill? A plaintiff's mill is this. It's an attorney's office that brings in as many cases as they can. They don't care what type of case it is, as long as it's a personal injury case. They'll take everything from a parking lot accident to somebody getting run over by an 18-wheeler on I-75. They take it all, absolutely take it all. What they do is they get it in and not always, but generally do the bare minimum on those cases. They will coordinate through a case manager, to make sure that the client goes to treatment. They'll order the bills and records. They will maybe take some photographs. They won't interview anybody. In fact, the plaintiff themselves may never even get talked to other than the fact that they signed a piece of paper. They'll take those cases. They'll get them to the point where treatment is done. They'll send a demand to the insurance company. They'll get a response back. They'll call the client. This is probably the second time the client's ever spoken to the attorney's office. And they'll say, hey, XYZ insurance company offered this much money on your case. Do you want to take it, yes or no? And there'll be very little information most likely offered as to why that insurance company offered what they did. But they just put the client in a position to say, hey, this is how much is going to go in your pocket. Do you want it, yes or no? And at that point, if the client says yes, they'll order checks and they'll cut checks and they'll do the things they do. The client will get their money. Again, not knowing if they got a good deal or not knowing if they were paid fairly, just knowing that that's how much money they're going to get. And they may even present it to them as, hey, this is all you're going to get. If the client says no, one or two things will happen. Either the mill firm will disengage from the client, meaning cut them loose, or they'll refer the client to another law firm. They'll tell them that, hey, we're referring you to this law firm over here for purposes of litigation. And then the client goes to another lawyer. Hopefully that lawyer that they've been referred to will actually litigate the case, actually look at the case, and work it up. A mill firm, that's all they can do. The reason that's all they can do is because they have so many cases and so few lawyers. In Albany, Georgia, I'm not going to name names, but I can think of at least 5 local mill firms. In Albany, Georgia, I can think of at least 3 statewide mill firms that use this business model. And the reason they use this business model is because they make a ton of money doing it. They make a ton of money doing it. I mean, where else can you make that kind of money signing pieces of paper and cashing checks? That's why you have venture capitalists getting into plaintiff's practice. I received a call last week offering me 7 figures if they wanted to finance my law firm to set up this type of practice. Clearly, I'm not going into debt like that. It's just not happening, and I'm not partnering with some venture capitalist from India. But nothing against venture capitalists from India, just I don't know them. But it happens all the time because they make so much money. They make money because they're not doing anything. I mean, that's how they're making their money. They're not doing anything. I mean, they have these secretaries, paralegals, case managers who are basically filling out a spreadsheet. Client went to this doctor's office, this doctor's office, this doctor's office, this doctor's office, and they have checks down the side. Do we have their bills and records? And they request those things and they get them. Once they get a full list saying, hey, we have all the bills and records, they put a cover letter on top of all that paper, send it to the insurance company, and in 30 days, they have an offer. Assuming the client takes that initial offer, they'll have checks within 10 days. And 7 days later, they're cashing checks or depositing checks. I mean, it's an absolute cash cow. But the client's not getting any justice. It's a perversion. It's an absolute perversion of the profession. And it's brought about almost, I can't say it's 100% because of, but it's a lot because of advertising. Because clients don't know they deserve better. Clients don't know there's anything else out there. Avoid the mill firms. Best way to identify a mill firm is to, again, ask about case count, ask about lawyers, number of lawyers they have, how many cases they have, ask about the number of staff they have. If they have 3 paralegals for every attorney or 3 support staff for every attorney, that's a pretty good telltale sign it's a mill firm. Ask about the number of cases they actually have in litigation as compared to the numbers that they don't have, that are not in litigation. I would say, I can't say with any certainty, but I would imagine that 20 to 25% of your cases should go into litigation. And make sure that they're filing those lawsuits in-house themselves, not through somebody else. I'll tell you a funny story. When I first came to Albany, I rented space from what I later learned was a mill operation. I'm sitting up there in my office, and this lawyer comes up the steps, and he says, hey, Beau, I want you to file a lawsuit on this case. I'm going to refer it to you. All right, yeah, that sounds good, no problem. And the lawyer says, but here's what I want you to do. I want you to put my name on the pleadings too, so that we're both attorney of record. No problem, absolutely. So I get to drafting up the complaint, drafting up all the things that we need. But before you can file something or put someone's name on an attorney's name on a lawsuit or any legal document for that matter, you have to put their bar number. It's pretty basic. So I go downstairs and I ask this lawyer, hey, I've got this all drafted up, but I need your bar number. Absolute deer in headlights. This guy had been practicing 30 plus years, deer in headlights. He says, I'll have to get back to you on that. Comes back 3 days later. His paralegal has retrieved his bar number, and we put it on the pleadings. Right there for me, the writing was on the wall. 2 months later, I got out of that place. Not where I wanted to be. Anyways, beware of the mill operations. Make sure that your attorney at least knows the litigation process, regularly engages in the litigation process, and when necessary, tries cases. And when I say when necessary, when the attorney's actually done all the stuff he or she's supposed to do and the other side is being unreasonable. Again, so many cases go to trial simply because of lack of workup, lack of doing what they're supposed to do prior to trial. And it does no good for the client. It does absolutely no good for the client. Yeah, just to wrap this up, it gets back to the central theme, which I hope everything in this episode was pointed to. Do not be persuaded by marketing. Hire an attorney. Don't hire a marketing company or a marketing firm. Attorneys are spending thousands. At the local level, they're spending thousands of dollars on marketing. I'm spending thousands of dollars on marketing. But I like to think that the reason that I'm doing that is not simply to market to you. First off, is let you know who the heck I am. Because if everyone's marketing and I'm not, the odds of you finding me are pretty slim. Secondly, it's my hope to actually educate a little bit, give you some things to think about so that you can parse through the marketing and make an educated decision about which direction you want to go. So it all goes back to the central theme. Don't be persuaded by marketing. Do your due diligence. Attorneys have dozens, if not hundreds of cases at any given time. You've got one, hopefully one. I hope you don't have multiple personal injury cases going on at any given point in time, but in most circumstances, you'll have one. You'd be surprised what some people have going on, but you'll have one. It's important that you get it right. It's important that you make an educated decision. It's important that you hire someone who can actually help you and wants to help you, as opposed to just push you through the system like it's some kind of processing plant. And I think that plaintiff's practice has become a processing plant simply because lawyers are allowed to advertise. They're allowed to take in as much oxygen as they can. All right, guys, hope you got some value out of that. If you're listening on a podcast, we'd really appreciate it if you'd leave us a review. If you're listening on a video platform, if you could like and share, we'd really appreciate it. Maybe share it with a friend that could use this information. Thank y'all.